Hello, friends. Welcome to the National Constitution Center and to this evening's convening of America's Town Hall. I'm Jeffrey Rosen, the president and CEO of the National Constitution Center. Before we start, let's inspire ourselves and motivate our panelists for the conversation ahead by reciting together the National Constitution Center's mission statement. Here we go. The National Constitution Center is the only institution in America chartered by Congress to increase awareness and understanding of the U.S. Constitution among the American people on a nonpartisan basis. We have a bunch of exciting programs coming up. Most saliently for tonight's topic, on March 27th, we'll host a live discussion in Washington, D.C. on the 5 amendments to the U.S. Constitution proposed by the NCC's Constitution Drafting Project. This was a wonderful initiative where we convened progressive, libertarian, and conservative scholars to draft constitutional amendments, and they agreed on the text of 5 path-breaking amendments to the Constitution. They'll present and discuss these amendments at a program co-hosted with Arizona State University in Washington, D.C. Join us live if you're able, or tune in online, and it'll be a great discussion. And then on March 30th, we'll have a conversation on civic virtue and citizenship with Richard Haas, Christopher Beam, and Lorraine Pangle. And please join for that as well. I'd like to thank our partners at the Center for Constitutional Design at Arizona State University and the Sandra Day O'Connor College of Law for their collaboration on this program as well. And we're honored to co-host with them. And now it's a great honor to introduce our panel. Wilfred Codrington III is an associate professor of law at Brooklyn Law School. He's co-author of The People's Constitution, 200 Years, 27 Amendments, and the Promise of a More Perfect Union. Rosalind Dixon is professor of law at the University of New South Wales. She's joining us from New South Wales early in the morning, and she's co-editor of the leading handbook, Comparative Constitutional Law, and its related volumes, and is also the editor of the Constitutional Systems of the World series. Her forthcoming book is Responsive Judicial Review, Democracy and Dysfunction in the Modern Age. And the Honorable Jeffrey Sutton is Chief Judge of the U.S. Court of Appeals for the Sixth Circuit. In addition to that distinction, he's the author of some extraordinarily important and illuminating books, including 51 Imperfect Solutions, States and the Meaning of American Constitutional Law, and most recently, Who Decides? States as Laboratories of Constitutional Experimentation. Thank you so much for joining Wilfred Codrington, Rosalind Dixon, and Chief Judge Sutton. Judge, let's begin with you. In your wonderful book, Who Decides? States as Laboratories of Constitutional Experimentation, you have a final chapter on the amendment process. And you note that Madison thought it should be hard to amend constitutions, Jefferson easy, and as in your great formulation, Madison won at the federal level and Jefferson at the state level. Give us an overview of the difference between how hard it is to amend the Constitution at the federal and state levels.
Yes, well, first of all, Jeff, as always, thank you so much. It's an honor to be with everyone, and thanks for inviting me. You know, Jefferson and Madison didn't disagree about much. They lived 21 miles apart. They're both Virginians, sequential presidents. They basically had exactly the same worldviews with this one key exception: what to do about the amendability of a constitution. And, you know, Jefferson thought it ought to be up for each generation. Back then, he thought of a generation as 19 years, and that you ought to be able to put up for a vote, a convention, kind of starting from scratch, both with the charter and rights definition. Whereas Madison, as you pointed out, thought that would undermine the venerability of any constitution. It is so striking in this country how different the views have evolved. Basically, Madison won the debate at the federal level. Article 5 famously requires 3/4 of the states to approve, ratify an amendment. That, of course, is very difficult today with anything remotely controversial. We've only had 27 amendments. 10 arguably don't count. The Bill of Rights, they were all part of a quid pro quo to get ratification of the federal Constitution. That leaves 17, and 2 of them are awash, passing prohibition and eliminating it. So we've really had 15, you would say, and that just proves Article 5 is quite a barrier to changing the Constitution, either to deal with mistakes in the underlying document, or changing circumstances and new norms. The states are a remarkable contrast where Jefferson clearly prevailed. We have 46 states, and I'm speaking generally, but this is accurate in the main. 46 states permit an amendment with a 51% vote. So once it's on the ballot for the people, whether through a legislative initiative, an initiative by the people, it just takes 51% of the folks to approve an amendment. The highest threshold is New Hampshire at 2/3, so that's still less than 3/4. Florida requires 60%, Colorado 55%. Delaware, interestingly, doesn't even have a vote. It just requires the legislature in 2 different sessions to approve the amendment. So that leaves 46 states where a 51% vote suffices. Now, the upshot of all this is that the states are just much more democratic. It being easier to amend state constitutions, I think we have in total in the neighborhood of 7,500 state constitutional amendments. At the federal level, we've had one constitutional convention, Philadelphia. At the state level, there have been 144. So you can see that the ease of amendment facilitates lots of change. And, as John Dinan, who's an expert in this area, says, there's not a state in the country where they have amended more infrequently than at the federal level. The plus of all this is that the federal side does create stability. It's probably a good idea to have a more stable national government. I guess the slight oddity is the state constitutions have evolved so much. So we just have so many areas that are just quite unrecognizable, direct democracy through the initiative, election of judges, a plural executive where you can vote for lots of different folks at the executive level, term limits. All of these things don't exist at the federal level, in part because there's such a barrier to change. And, I'm not going to say it hasn't worked well, but it is puzzling that the same people would approve such disparate approaches to amending a constitution. You might think if the people of Mississippi, Colorado, California, and Ohio had the same view of amendment, they could change it at the federal level and do at the federal level what we've done at the states, but that is not how it's worked.
Such a helpful overview of the difference between the federal and state systems, the dramatic ease of amendment at the state level, which isn't present at the federal level, and the history in your great book, which teaches us that it wasn't until 1818 that the state allowed people to ratify legislatively approved amendments, but that now, as you just told us, 41 states require a majority vote of the people to ratify. Rosalind Dixon, give us a sense of how the U.S. Article 5 method of amending the Constitution contrasts to systems around the world. You've identified 3 major buckets when it comes to constitutional amendments. The first, flexibility and rigidness in the amendment process. The second, the plebiscite approach. And the third is Article 5, which is very much of an outlier. Tell us about the differences between Article 5 and those other 2 approaches.
Well, thanks, Jeff. I think that the most pithy way of putting the US Article 5 procedure in comparative perspective to say it's truly exceptional in the difficulty of amendment that it imposes. There was a famous study some 20 years ago by a very respected professor of political science, Donald Lutz, where he said the US Constitution was the second most difficult in the world to amend after Yugoslavia. And of course, Yugoslavia no longer exists in the form that it was studied at that time. And so the US Constitution really is, by almost all accounts, the most difficult to amend in global terms, by virtue of both the degree of supermajority requirement for support in Congress and the Senate, and then the ratification requirements in the states. So it's extremely rigid in global terms. And as you note, it's not only that it's more difficult, it involves less popular involvement than a large number of countries worldwide and the US states. If I may, let me just respond a little to Judge Sutton. the Chief Judge says, well, this has implications. I want to highlight 4 functions that I think a flexible amendment rule can play. The first is, as the judge said, mistake correction and updating in light of changing circumstances. But there are 2 more. One is about the renewal of democratic consent, which is a hypothetical function, but an equally, if not more important one. And one that goes along with that, which is especially important in many other democracies, is that the legislature and the people have tools available for overriding the Supreme Court or the Constitutional Court, where they render decisions that meet with widespread reasonable disagreement. So it's another tool for legitimating judicial review, as well as renewing consent for the Constitution. I do want to suggest, however, that any kind of upbeat analysis that suggests that Article 5 has created stability by making the Constitution rigid is too upbeat, because the way in which we understand formal amendment, as under Article 5, has to be put in the context of informal modes of change. So when you have a really rigid Constitution, it puts pressure on the judiciary to do the updating, and it also encourages Congress and the executive to find what Professor Mark Tushnet has called constitutional workarounds, ways of dealing with an overly outdated and rigid Constitution that involve kind of fairly creative ways of lawyering around the Constitution. And they are a necessary part of American modern government, but they are not desirable from a rule of law perspective. So I think in global terms, Article 5 is rigid and an outlier in ways that are democratically problematic. But let me, for American pride reasons, note 2 things that I think actually are innovations in Article 5, which have been picked up in some ways elsewhere. The first is a very nefarious clause in Article 5, which is the freezing of the slavery compromise, has been used elsewhere, not in relation to things as problematic as racial injustice, but rather other desirable features have been baked in for some time in order to promote stability of a compromise. And the more important enduring design innovation in Article 5, again, designed for the wrong preservation of the equal, voting of the states in the US Senate, that kind of tiering, it's really hard to amend the US Constitution, but it's impossible to amend the equal representation of the states in the Senate because it requires their consent to change it. That kind of tiering is best practice now globally. And the version of it that's been picked up in South Africa and by kind of judicial interpretation in Kenya and in India and Colombia is one that says some things should be rigid. As Chief Judge Sutton said, we don't want everything to be up for grabs all the time. That's why the US Constitution sitting on top of state constitutions is such an important stabilizing force. But there's a whole bunch of stuff that we want to be more flexible for all the reasons that I've indicated. And that kind of tiered structure that you see in the origins of Article 5 has been picked up and redesigned for global best practice around democratically sensitive processes that are 2-track, higher and lower track, depending on the democratic fundamental importance of the provisions at stake.
So interesting to learn about those 2 tiers. I'm just going to ask, what are specific examples of the unamendable or hard to amend tiers in South Africa, Kenya, and the like?
So in Colombia and India, these tiers have been developed by judicial implication. And so there's always a kind of standard like fuzziness where they say it's the fundamental character of the Constitution or it's the basic structure of the Constitution. And we know that that includes the separation of powers. It includes the presidential term limits in Colombia in ways that are designed to prevent a single president from appointing all of the other independent branches. In Kenya and South Africa, it's more defined in the text to refer to basic founding values of the Constitution around dignity, equality, and freedom, as well as certain important structures around federalism and the separation of powers. And I think that the Kenyan South African model really is best practice, but every country is going to have to figure out what's on the higher versus lower tier in a way that is contextual and that takes into account its own history, its own values, and its system of government. presidential systems are going to have to put different things on the higher tier than parliamentary systems because of the very nature of how democracy functions in those systems.
Very interesting to learn about those high tier provisions, and also your very thoughtful observations about how amendments can engage in both mistake correction, also the renewal of democratic consent, and the legitimating of judicial review. And Wilfred Codrington, I'd love to ask you about that point. So many of the significant amendments to the US Constitution, as you've argued in your book, the People's Constitution, have been in response to Supreme Court decisions. And there have been, you and others have suggested, perhaps 6 amendments that have overturned Supreme Court decisions. Tell us about them and the role of these decisions in precipitating constitutional change.
Sure, and thanks for the question, Jeff, and for having me. And just kind of tying on to what Rosalind said quickly, is that the difficulty of amendment in the United States is very much the backdrop to a lot of the conversations and debates in constitutional law. So, and that probably first and foremost is judicial interpretive methodologies, right? So how are we to read this Constitution in light of the fact that it's not very easy to update it? And so that's something that just goes on. But to your point more specifically, yeah, it has been about a half dozen, up to 7 different times, depending on how you count the holdings and the takeaways from these cases, that the American people have amended the Constitution to displace a Supreme Court ruling. So that happened first with the 11th Amendment, and the 11th Amendment basically disallowed citizens from a state to sue the state, and so this citizens from another state to sue a state, and so this was, at least in discussions about ratification, perhaps a misreading of what was supposed to be the case. And in the wake of the Revolutionary War, where there was a lot of debts, this kind of became an issue, and the 11th Amendment actually just sailed to proposal and ratification quite easily. And so we have that, and there's a number of things that stem from the 11th Amendment that we can debate today, if that was the initial meaning of the 11th Amendment. But that was the first time it was done, and that was in the 1800s. Following that, we've had it on a number of other occasions. The most famous one would probably be the 13th and 14th Amendment, which were ratified in the wake of the Civil War. And that was to overturn the ruling in Dred Scott decision. And in that case, the justices basically said that Black people were not people for all intents and purposes, not citizens of the United States, and they had no rights that the white man was bound to respect. And so it took a war, the Civil War, to kind of get to the point that we could amend the Constitution. But then we had 3 Reconstruction amendments basically undoing what the court did there. We got one famously in Pollock versus Farmers Loan and Trust. So that was the case where the Supreme Court said, despite the fact that the national government had imposed income taxes specifically to fund the Civil War and other ventures, that Congress doesn't have the power to do that. Congress does not have the power to tax on income. And so we got an amendment to overturn that one in the early 1900s. And I'd say the most recent one that might be worth discussing is the 26th Amendment. And the 26th Amendment lowers the national voting age to 18. And that displaces a ruling, a very complicated ruling that touched on a lot of things, but specifically when Congress reauthorized the Voting Rights Act in the 1970s, they included a provision to lower the national voting age to 18. And the Supreme Court basically said in this fractured opinion in Oregon versus Mitchell, well, Congress, you have the power to do that for federal elections, but you don't have the power to do that for state elections. And so as Judge Sutton just talked about, we have 50 different constitutions under the Constitution. They all have their own unique procedures for amending the Constitution, for being amended themselves. And a number of them at the time actually required these amendments to go through 2 different sessions to be adopted. And so with an election coming up and sort of a federal election age in place at 18 and various ones at 18, 19, 20, and 21 in the states, we amended the Constitution very quickly. It was ratified in 3 months, so it was the fastest one ever ratified, to ensure that we had that uniformity in the national voting age, and state election administrators would not kind of have the difficult task of trying to navigate 2 different electoral systems. There are several more, but I think those kind of represent a number of important ones during the different waves of amendment that we've had over the course of the 200 and some odd years.
It's so interesting. Thanks so much for that. In your book, The People's Constitution, you identify the 4 eras you've talked about: the founding era, Reconstruction, progressive, the New Deal, and then the Civil Rights era amendments, and the 1970s. Sorry, it's a series of eras. And Jeff Sutton, I want to just jump off of the 70s. It is remarkable that between 60 and 71, there were 3 voting rights amendments, and there were a series of other amendments that were proposed and nearly got through, but didn't. There was an amendment to reform the Electoral College that, had it been proposed by Congress, would have been immediately ratified by the states. It was endorsed by both political parties. It was blocked by a few Southern votes in the Senate. Why was it that the federal Constitution seemed so easy to amend in this burst of voting rights amendments in the 70s, and now it seems essentially unamendable? And then tell us about what's going on at the state level, where in the wake of Dobbs, as you've noted, some think the Constitution is too easy to amend, and the pro-life forces are proposing to make it harder, to raise the bar to 60%. Broadly, is it too easy to amend the Constitution at the state levels? And tell us what's going on there.
Yeah, one way of thinking about what Wilfred was just saying in kind of the sweep of American history is, yes, it is difficult. And the idea that the US Supreme Court has only made 6 mistakes in nearly 250 years is, of course, can't be right. And so what are we doing? Rosalind correctly pointed out that it's amendment by interpretation is what has really happened. But even so, even if that's fair to describe as something that has happened intermittently, we did once have a tradition of using amendments as the approach to deal with either an incorrect decision or perceived incorrect decision or shifting norms. And I do worry that that tradition has disappeared. And I'm not an expert in political parties, but I'm going to guess that there was a time where they thought it was to their advantage. It was actually good for them politically that they had to seek ratification in all 50 states, because if they had a winning issue, let's say giving women the right to vote, they were ultimately going to prevail, and that was going to be a positive thing to be pushing in each of the states. That was probably true with giving 18-year-olds the right to vote. I find it fascinating and, to me, disappointing that the ERA did not succeed. That was it's just so interesting that you get 30 states almost right away. Within a couple of years, it looks like it's just going to get right through, a little bit like the amendments Wilfred's talking about, and then it shuts down, and they extend it, and they come up 2 states short. So if to give a concrete example, if the amendment requirement in Article 5 was 2/3, the ERA would have been a constitutional amendment. Of course, what happens next is an unfortunate lesson for the typical American. You get US versus Virginia, which is a decision that, I'm not going to say makes the ERA irrelevant. For those who care about those issues, you want it in the Constitution, not just a decision. But practically speaking, US versus Virginia does really essentially what the ERA would have done. And the thing I might point out at the state level, it's true we have so many more amendments at the state level, but one thing that's consistent with the absence of success with federal constitutional amendments in the last 40, 50 years is at the state level, we've not had successful constitutional conventions for a very long time. And that, that if you ask me, should have Americans looking in the mirror. Why is it that we traditionally have been able to do that, see compromise, whatever it might be? It makes you worried a little bit that there's very powerful interest groups that would make it quite difficult to get through a convention in a way that would be very successful. You're quite right that with the Dobbs decision, it not only has put a spotlight on state courts and state constitutions, because after Dobbs, anyone seeking a right to choose, for example, is going to have to get relief from a state legislature, a state court, or a state constitution, maybe state constitutional amendment. And because the state constitutions are so much more easy to amend, that's a hopeful prospect for somebody that is worried that maybe the state legislature is unwilling to enter the fray, or what they're willing to do in entering the fray isn't go as far as someone wishes. And 18 of the states allow a direct democracy, a constitutional initiative that, of course, goes right around the legislature. The legislature has no role in that. And so it's really been fascinating since last June to watch not just the activity of state courts. We had 3 states for the first time recognize explicitly a right to abortion in their constitutions. So, I think it was Vermont, Michigan, and California. So that was just last November. One wouldn't be surprised to see more of this in the future for many of the reasons we've had proposed amendments in the past. You not only support the idea, but you might think it's useful for your particular party when it comes to getting people out to vote, which I think Wilfred would agree is not an unheard of phenomenon when it comes to putting something on the ballot. So the fact that 46 of the states permit amendments with a 51% vote, the fact that 18 of them permit direct democracy, make constitutional amendments look like a very useful tool in the toolbox for people that care deeply about that issue, frankly, in either direction, right? It can help you in either direction. There's one of the things that's, I think, both happy and sad about state constitutions and this whole debate is it's ultimately quite neutral. It doesn't tell you what should be done. It tells you the ways it has to be done.
It's so interesting and absolutely showing the range of options is very powerful indeed. Rosalind Dixon, in defending tiered constitutional design, you say that a moderate level of amendment difficulty is a good compromise between the strengths and weaknesses of being too flexible or too rigid. Can you give us specific examples of success stories? You've noted that the South African Constitution is one example of tiering. Has that led to effective protection of individual rights and responsiveness to popular sovereignty? And maybe give us a sense of other success stories and then some cautionary tales around the world that are less successful in striking that balance.
So I think it's a really important question when we look around the world, not just to look at the provisions, but to pressure test them, in operation. I'm going to answer the question in a slightly roundabout way, if I may, which is picking up on Judge Sutton. I think that, one can look at why has it been so difficult in the US, and then why are people either in favor or against the kind of post-Dobbs plebiscitary turn in order to understand some of these issues. So the first thing I think is worth noting is that the US rule has, and this is some of the research I've done with Professor Richard Holden, has de facto got harder as the number of states and numbers of members of Congress has gone up. That's a kind of statistical finding. But surely since the 70s, polarization in American politics has been a huge problem for Article 5 style change, which is Article 5 is premised on the idea of a kind of either non-partisan in the founding moment or bipartisan approach to constitutional change. And bipartisan politics is basically dead in the United States right now, which makes constitutional change equally challenging. And if you look around the world, understanding party politics as a vector for success or failure in amendment design is really important. So if you look at South Africa, one of the reasons it has been successful is that it set a 75% threshold, which looks really difficult, but that the African National Congress, which was a dominant party coming out of the liberation movement, got close to but never achieved sole control of the amendment threshold. So in the first post-apartheid elections, they got in the low 70s. And since then, that they've kind of hovered around the 60s, 70s mark, never achieving complete dominance of the amendment process. So they've been in a position to command the ability to drive change, but not unilaterally impose it. And the party political configuration really impacts how formal design rules work in practice. And I think that's a really important thing for us to understand, both the challenges of the US and where success has arisen elsewhere. My own view is if we can fix the partisan polarization in the United States Congress, we can also fix amendment over time. And that's really a kind of a big part of the challenge. On the Dobbs issue, I just want to resist the idea that what I recommend is moderate difficulty. Actually, what I'm trying to suggest is there should be real flexibility on some issues and real difficulty of amendment on others, so that the kind of moderate approach is the averaging it out. Whereas in general, I'm suggesting you want to go high and low depending on the issue. So on Dobbs, the easy answer for progressives is to say, well, plebiscitary change is fine here because it's just adding to the protections that women enjoy. It's not taking anything away. But for the pro-life movement, it is taking something away. It's taking fetal rights away. And so whether you regard it as too flexible or not depends obviously a great deal on where you start. Supposing one were to take both positions seriously and say that we take both the pro-life and the pro-choice view on the kind of basic core of what's difficult to amend, I think you would say that the kind of democratic experimentation that is arising post-Dobbs is perfectly fine democratically, but not if it allows for abortion on demand at all stages of pregnancy. That's insufficiently protective of the fetus and its interests or rights, and not if it restricts access to abortion in a range of circumstances necessary to protect women's health and dignity, and certainly life. And so I think my own view is that if you were to take a first principles approach to the design of the kind of post-Dobbs experimentation, you would say, great, let's embrace plebiscitary experimentation, but not if it takes away basic rights of access to reproductive health care, and not if it gives no credence to the importance of people's commitment to fetal life by imposing at least some, if you like, moral suasion against access to abortion without due consideration and attention to the stage of pregnancy.
It's such a provocative suggestion that I'm going to ask the follow-up question. There's no mechanism for putting certain values off the table in the US context. There's some constitutions around the world that would allow for the solution that you suggested, where there's debate, on the margins, but not about the basic interests of women and fetuses?
So the German Constitutional Court has had to grapple with the abortion question from the opposite direction to the United States. So the challenges that have come to the German Constitutional Court have been from pro-life legislators challenging the decriminalization of abortion in Germany through the 70s into the 1990s. And the court basically struck down decriminalization efforts, saying that they were insufficiently protective of the dignity of the fetus, but saying that it was equally important for women's dignity to be protected. And so some balance had to be achieved. And the court did so in reliance on Article 1 of the Basic Law, which is the right to dignity, which post Holocaust was made unamendable. So the dignity-based interpretations of the Federal Constitutional Court of Germany are not amendable. And so the balance that the court has struck between fetal rights and interests and women's rights and interests is one that has evolved, and there's been pushback from civil society to the court, but which is fundamentally on a higher tier because it's an interpretation of the dignity clause of the Basic Law, which is unamendable.
Thanks so much for that. Wilfred, Codrington, Rosalind Dixon just suggested that polarization in America has made it difficult for social movements to enact their will into law. In your book, you talk about how consensus from the ground up of social movements in the progressive era and throughout American history has been the main engine for constitutional change. What to do in an age when polarization seems to have made the mechanism that the framers anticipated for amendment hard to deploy?
Yeah, it's interesting because in our book, we actually grapple with a number of factors that we tend to see in these periods of amendment or leading up to them. And two of those factors, one of them I already discussed, which was unpopular Supreme Court decisions and a response there. But two of the other ones are sort of social and demographic changes and the movements that respond to them, and political polarization. So they both tend to be present around periods of amendment. And so speaking to political polarization, we are obviously seeing great political polarization during this era, but that is not abnormal. We saw political polarization in each of the four waves of amendment that we discussed. So in the founding era, the Federalists had, as our former president said, shellacked the anti-federalists, and they really didn't even need the anti-federalists to get the Bill of Rights. And in fact, there was a debate over whether the Federalists were going to follow through with their promise and propose the Bill of Rights. So that happened, and it did get the bipartisan support, but it didn't even need it at the time. During the Reconstruction era, the Civil War, I mean, that was completely one-party politics at the time. You didn't really even have a Democratic Party, or at least most of them, because most of the Southern states were not acting as members of the polity. And so it was the radical Republicans that pressed through their agenda and gave us the amendments of that time. And there are some technical issues about how that was done, but that was mostly one party. During the progressive era, you just kind of get this, the progressive era is really interesting because you get this push from populism to progressivism that really strikes a chord with both parties, and you kind of get the splintering. So you get support for the income tax and the direct election of senators from both major parties, members of both major parties. And so those seem to be, those broke through the polarization that had existed in the lead up to that. You had really close elections. You had two misfires of the Electoral College where you got the popular vote winner losing the presidential election. That was all in the lead up. So there was intense polarization there, but there was a breakthrough. And similarly in the Civil Rights era. The Civil Rights era was this period where, again, you had the Southern Democrats not really on board with any of these progressive amendments, particularly the voting rights ones and the ones that were sort of trying to grapple with racial justice during the era. But you had Republicans pushing it and Democrats from other areas of the country. So, and we've seen a realignment where, you know, most of the South now is not Democrats where they used to be. And so that is part of the polarization we see today. So it is there are these social movements that sort of exist and they push these issues that are related to fundamental changes going on in society, economic, demographic, technological, and things like that. And often they have a constitutional agenda and a constitutional reform agenda. And it's not clear if that pushes through the polarization or if there are other factors that make the polarization go away, but both are connected to periods of amendment, at least at the federal level in the United States.
Great, thank you for that. Judge Sutton, tell us about the argument that some state constitutions are too easy to amend. You talk about California, which uses the plebiscite, which it adopted in 1912. In no other state, you quote the former Chief Justice of California saying, as the practice is extreme in California, which allows petitions to be placed on a ballot with 8% of the voters and then can approve by majority. Tell us about how the initiative or plebiscite is fared in California and in other states that use it, and whether or not that's a cautionary tale.
Justice Black on the US Supreme Court used to proudly point out that he carried the Constitution around with him in his front pocket, and wouldn't have been one produced by the National Constitution Center, but one could imagine that happening today, I would say with Justice Gorsuch. a justice from the California Supreme Court or the Alabama Supreme Court, really most US Supreme Courts, who tried to carry the state constitution around with them, not only couldn't put it in their jack pocket, they need a pretty sizable backpack. And it's astonishing. And, you know, the words, I think, I don't think I have this exactly right. I'll bet my co-panelists will have this number, but, you know, the US Constitution comes in, I think, in the 7,000-ish words. Jeff, you probably know this exactly. I think the state constitutions average in like the 30,000 range. So it's an astonishing difference. And I do think it reveals that in America, we might have a group where it's too easy. And you run into this problem that if you constitutionalize everything, you're constitutionalizing nothing. I mean, you're really breaking down the distinction between what a constitutional provision is and what a statutory provision is. And that doesn't seem healthy. I mean, that seems to me quite dangerous. One can worry that a reason for this is interest groups, that interest groups that desire something in a given state would prefer, all else being equal, to put it in the Constitution rather than a statute. You really see this dynamic. This is one defect in quite a few state constitutions. Quite a few of them make it about as easy to amend the Constitution through an initiative as they do to amend a statute by a referendum, right? So referendums are generally creating statutes or fixing statutes. Initiatives, generally speaking, adding something to the Constitution or changing something. Well, if you're going to make those two requirements roughly the same, who wouldn't take the constitutional route? And that strikes me as problematic. The thing about whether initiatives are the blame, it is true. I don't know this for sure, but my suspicion is many of the state constitutions that are the longest are states with initiatives, but I can promise you that's not exclusively the case. So one can worry that the ease of putting something on the ballot, riding a wave politically of something popular at a given time is, unfortunate and not the way we should run a government. But that said, what's easy to add is easy to subtract. And I find it interesting that not too many initiative states have subtracted. At the same time, one would have guessed, Wilfred was talking about the progressive era when the initiative idea came to the fore. Lots of states got on this bandwagon pretty quickly. Then it slowed down and then it stopped. You would think that would be a rather easy thing to get people to agree to if you're thinking of, oh, well, why wouldn't I want to have the right to vote to amend the state constitution? Well, you haven't had many states. I think it's been quite a while, actually, since a state had an initiative, which suggests to me it really does have some warts, or maybe ought to have a higher barrier to entry. A good example of a state that, in my view, attended to this issue is Florida. In one sense, they facilitated initiatives by creating this ongoing constitutional commission, which gets together every 10 or 20 years and proposes things directly on the ballot. But one thing they did in return is raise the requirement to 60%. And, that strikes me as healthy. If I were speaking for my own state, I would much prefer to see it at 60% rather than 51 as it is in Ohio. And frankly, I don't know how my co-panelists feel, but I don't think we'd be hurting or destabilizing the federal constitution if we dropped it to 2/3. I think we would increase the likelihood that we would take Article 5 seriously and decrease what has become our tradition too frequently, in my view, of amendment by interpretation, which I think everyone here knows is not cost-free. It runs the risk of politicizing the high court. And, that's the world we're in right now. I'll just make one other brief point, just because I know, Jeff, you're going to love this. The whole debate we have about living constitutionalism, originalism, and it's just so intense. It's almost political parties at this point. That grows out of the phenomenon of amendment by interpretation, right? We wouldn't, in a world in which a constitution could be amended by 51% vote, it kind of sounds silly to talk about amending through why would you have an evolving guarantee when it's so easy just to change the darn thing? Or if you did, it would be the rare exception. Whereas in our case, whether it's structural or rights provisions, a lot of things are on the table when it comes to accounting for new norms. And I think that follows from the difficulty of amending it. And, I'm not saying this fixes everything, but I sure would be happy to see it go down to 2/3 and have the states go up to 55 or 60.
That's such an interesting point about how our originalism, living constitutionalism debate flows from the difficulty of amending the Constitution, both in leading judges to be more expansive and interpreting the Constitution in the 20th century and leading to an effort to constrain judges in the 21st. And your suggestion that the Constitution be a little easier to amend is shared by our Constitution drafting team, which unanimously proposed making both proposal and ratification a little easier, not much.
Well, they have a vote in Ohio. They've got one on the plus side in Ohio.
We're getting to 2/3 already. I think you can feel the bandwagon. Rosalind Dixon, examples, if you could share with us, of constitutions around the world that are too easy to amend. Have countries around the world found this California plebiscite problem of 51 being too low a threshold? And then tell us about Israel, which is an example that several of our friends in the Q&A have asked about. Is the current constitutional crisis in Israel a result of the fact that the Constitution isn't written down, or is it a lack of separation of powers that allows the executive to assault judicial independence? And what lessons can we take from that?
So too easy, I think absolutely, going back to my prior remark, is that if an amendment rule is set with a view to it being a kind of bipartisan or multi-partisan threshold, and then a particular party gets a lot of power, all of a sudden it's extremely flexible, right? So Mexico, India, various times, have had dominant parties that have just simply had more legislative representation than the amendment threshold. And so they've amended willy-nilly. And it's partly why courts like the Indian Supreme Court came up with implied limits on the amendment power, like the basic structure doctrine in Kesavananda, because they were very concerned about the degree to which, in Judge Sutton's words, it was kind of becoming change that looked like legislation, highly partisan, some of it very anti-rule of law. Gandhi used amendment to insulate herself in ways that Netanyahu is now doing in Israel, and they were seen as very problematic. So that is why at the back end, courts came up with these implied limits that were designed to kind of tier the Constitution ex post in order to counter this problem. In terms of plebiscitary politics, people often talk about Switzerland as an example where there's generally a fairly well-designed balance between rigidity and flexibility, but where the initiative process has actually produced some very wacky amendments in the last decade or two. If you like, if you're on the left, you might like the fact that they tried to ban holiday homes by plebiscite, but you would also be concerned by the Islamophobia in some of their other plebiscites around mosque building. So I think that the California of Europe is Switzerland, and there are some concerns there. I have an article on the Swiss constitution where we propose that the Supreme Court of Switzerland should deny those plebiscites full effect in law until they are ratified by the federal parliament. So a kind of reverse engineering of a tiered structure where you need congressional implementation of a plebiscite before it can take legislative effect. But definitely there are those kind of cautionary tales, some of them easy to predict, as in Switzerland, others much harder because it's a matter of how politics plays out. If I may, I just want to say something very brief about Judge Sutton's invocation of Justice Black and the Constitution that fits in the pocket. Of course, Justice Black had a very textualist justification for that, kind of image. He wanted to invoke the idea that the Constitution was a written document and that was all, and it had to fit in the pocket. But there's also a really broader rationale for that, which is if you want people to understand the Constitution in the way the National Constitution Centre sets out to do, It has to be, not a long novel. It has to be a document of government that can be accessed and understood. But I think the experience elsewhere is that you can create, again, tiers of a constitution where, if you like, judges carry around the kind of high-level constitutional values in their pocket and they leave the detailed provisions in their office. And that actually works for popular imagination as well. I have an experiment with Professor Landau that we report in our article on tiered design, where we actually tested on MTurk how quickly people kind of lost a sense of the Constitution by how long it was. And it drops off really fast. And so I think there's a really important difference, not only between how difficult constitutions are to amend within a constitution, but how specific they are. And I think you could imagine a tiered structure where there's a kind of flexi-specific constitution that looks a lot like legislation, actually. And it's about whether, the locality or the state has water responsibility. And then there's a kind of abstract and entrenched set of values and founding principles that everyone carries in their pockets, they learn in elementary school, and is really hard to amend. And I think that we can have a black vision for 2023, but one that's more tiered and that does take seriously Judge Sutton's critique, because there isn't that kind of rendition of a super constitution for California, but there could be. And that's what the work we could do if we were redesigning from the ground up.
Thank you so much for that. We have some questions in the chat about what specific aspects of the amendment process are our drafting team trying to achieve. And the proposed amendment would make it easier to propose amendments by lowering the threshold for ratification from 2/3 of Congress and 3/4 of the states to 3/5 of Congress and 2/3 of the states. So like Judge Sutton's proposal, it makes things a little easier to amend, but not much. Wilfred Codrington, do you have proposals for amending Article 5? And if so, what might they look like?
Yeah, so I'm in agreement with, I think, Oliver. I don't think Rosalind weighed in on whether or not we should amend the US Constitution as amending provision, but I'm in agreement with most scholars who say ours is too difficult and it should be reformed. Of course, the paradox there is that we have to amend the Constitution to amend the provision. But were I to do that, yeah, I think that there are various ways to think about it. So one is just simply lowering those levels, as teams for the National Constitution Center are doing, as Judge Sutton mentioned. There is the tiered design that Rosalind mentioned. So you can do certain things. Obviously, this time it wouldn't talk about slavery or the Senate in that, or maybe it would talk about the Senate, but it wouldn't talk about slavery in the way that it did in Article 5. Another way is that you can adopt some things that other constitutions in the states and around the world do, which is to also put some of this to the people, right? Whether you do that sort of directly or you do that sort of on the backhand to adopt something that the legislator has proposed or something that states have proposed. There is an alternate way of amending the Constitution, which we've never used, and it just bears mention particularly because Judge Sutton talked about conventions, constitutional conventions in the states. There is a provision that allows a convention to amend the Constitution, where Congress would have to call this convention if you get 2/3 of the states petitioning to Congress for this. And so we've never had this, as I said, and we don't really know what that would look like in terms of rules. We don't know what quorum requirements would be like, delegations would look like, the agenda, and whether or not they would have to stick to certain things. But that's another way of proposing. I think that there are just several options out there. And right now, while in the beginning, in the founding era, it may have made sense to set such a high threshold. A lot of the factors that we think about, the admission of new states, the sort of permanence of two-party systems, and other things have just made that such a high threshold. So I'm open to a number of different ways to reform that, but I do think that some way allowing the people to weigh in on it more directly would be helpful. We are not a nation of states or sort of in this way that we were when we came together. We are a more unified country right now, or at least we hope we are. And so I think, having the aggregate, the entire polis sort of weighing in on these questions would also be helpful, not only just for the Constitution itself, but for civic engagement in a time where we, see voting at low levels, and we see people just sort of dispirited about the level of gridlock and traction at the federal level. So I think reform would be good in some way, and I would think about a way for engaging the people more in that process.
Such a thoughtful suggestion that the people be engaged in constitutional reform, and it nicely ties up this wonderful discussion, because we learned throughout the course of it that at the state level, the amendment process became more democratic, initially being purely legislative and then bringing in the people. And we've also learned that around the world, that kind of popular participation is increasingly common. I'm so grateful to you, Judge Sutton, Rosalind Dixon, and Wilfred Codrington for a marvelous discussion of this complicated and crucially important question, and for teaching us so much from a comparative perspective around the world and between the federal and state system. This is part of an ongoing series of conversations, and it will be an honor to convene all of you again before long. Thanks to our friends for taking an hour in their evenings to learn about the Constitution and constitutions around the world, and from all of us at the National Constitution Center. Good night. Thank you so much.
Thank you.